Okay, everybody. Hello. Welcome again. Good morning, and my name is Lynn Drinkwater, and I'm the program coordinator here at the Moore County Department of Aging and Senior Enrichment Center. And I love to start out this way, but how many of you in the audience, this is your first time here? All right. Thank you so much for coming. I hope it's a new relationship that you have with us instead of just a one-time thing. So it's a wonderful building, and we have calendars and news out in the lobby, and you can give yourself a tour afterwards, but we have a lot of great things here. One of my favorite things to do is develop educational programming, and it's so easy for me when I have wonderful people like Jennifer Garner with Garner Law Firm, who is always ready to not only come and do a wonderful presentation, whether it's a video, anything, whether it's refreshments, door prizes, sponsorships, she's wonderful. If you've never heard Jennifer speak before, the thing I love about her is she makes all of the legalese so much easier to understand, which is very helpful. So Jennifer gave us all this wonderful Panera breakfast this morning, so thank you very much for that, Jennifer. And so now we are live broadcasting this, live streaming on our YouTube channel. And what that means is, say in a month or two, you're thinking and you go, wait a minute, what did Jennifer say about this? You could go to our YouTube channel and you would find the video, because now the video will actually live on our YouTube channel. You can find that information in our newsletter down in the lobby. So without further ado, I'm going to introduce Jennifer Garner. And Jennifer, you have two choices. You could either stand right here with the microphone, or you could hold the microphone, however you like it. Okay? Thank you so much.
Thank you to Lynn. She does a great job here. That's why I'm willing to come back. She does a great job, and she gets me out of the office for a little while. There were plenty of fires to put out this morning, but I escaped. So let me know if you can't hear me. Let me know if I get too wound up and too excited about all these great topics and I talk too loud. So I have a tendency to do either one. Just raise your hand. I'm also happy to answer questions. There is going to be time at the end to also ask questions. So I gave you a handout mainly just so that it keeps me on track so I don't miss anything that I thought might be important for you. But it also gives you some little space to jot down a question or to take any notes that you need to take. I didn't do a case study today. For those of you that have come and heard me speak before, sometimes we do have a little fun with Donald and Daisy Duck or Minnie and Mickey Mouse and kind of put things in perspective with an individual person that we can talk about. Today was more kind of a broad brush stroke of the things that you would need to know if you were going to go and see an elder law practitioner or an estate planner, or a combination of the two. And it's kind of hard to talk about those documents in detail when you're trying to keep up with an artificial case study. So for those of you that have a great time today, welcome you back next week when we do part two. Part two, I probably will work through a specific case study because I'll be talking about levels of care and facility care and home care and Medicaid and veterans benefits and some fun stuff where we might want to put assets and names attached to our examples. So what is elder law? Elder law is a little different. It's relatively new when you talk about the law. Most of our laws go way, way back to the beginning of time and civilization, or the 10 Commandments, where however far back you want to go. It's basically helping your clients and their families through every stage of the aging process. That doesn't mean we want to see you at the very end of your life in a crisis plan. We do that. And it's harder for everybody when we're dealing in crisis mode. So we love to meet people on the early side. And then we work them and their families to the extent that they want their family involved and that they do releases for their family to be involved to plan through the whole aging process. And that's regardless of their health or their disability. And we want to maximize their desires. What do you want to have happen? Where do you want to be? Do you want to age in place? Do you want to go to facility care? Do you think you'll move and go live closer to a child? just be sure if you do that, that you're really sure your child is interested in you moving there, and that you will actually see them more often than you do living here. And if you do move, please be sure that you are very open-minded and ready, willing, and able to meet new friends and new community folks. Find places like a local senior center where you can meet folks who have similar or same interests. You can meet members of the community, find out what's available to you. I find some of my clients move and just sit in their apartments and are very sad about having left their friends and church members and all of the community resources that they were well aware of prior to aging to the point where they didn't want to go out and start that life over again. So you can plan to basically leave your legacy by saving resources, maybe leveraging benefits that are available to you. And all of that is part of the elder law and planning process. So it is lifetime planning. It's planning through the different stages, making sure, of course, that you have the standard documents in place to age through that. But it's never too early to start. It's not only crisis planning. And the earlier you plan, the more options you have. And that way you get to choose how you want things to go. What is my care going to be like? What decisions do I want to make ahead of time? And just give my family direction rather than just giving them powers. It also includes special needs planning. So a number of my clients have special needs members of their family. That may be a mental handicap, that may be a physical handicap, that may be an ailment that they know is going to result in a mental or physical handicap. And there are specific trusts and specific ways that you want to take care of those special needs individuals because you are harming them by leaving them assets. And so, sometimes grandparents will come to see me and they want to leave money for every grandchild in their estate plan. And one of the things that I like to ask them is whether any of those grandchildren have a disability. If any of those grandchildren have a disability, what benefits do they receive? If they are receiving benefits and those benefits happen to be asset or income based, that grandparent is actually harming that grandchild by leaving them a gift. And so sometimes we have to incorporate the estate planning of your children in that case, who may have already planned for their child in their estate planning. So your grandchild might already have a special needs trust or a fund that is available to them with a charity, for example, that will provide them with extras. Our government programs are far from perfect. Unfortunately, they change all the time because there's people up in Washington and people in Raleigh that love to tweak and change things. Sometimes they know how those programs work and other times they have no clue, but they change them anyway. So we have to be ready for that if at all possible. With benefits, for example, if you have a special needs grandchild that's living in a group home, it's impossible to private pay for a group home. There's no such thing. If that child doesn't qualify for the government benefit that funds group homes and benefits for handicapped children, then you just have to figure out a way to take care of them in the private community, which is very difficult, if not impossible. So elder law involves that special needs planning as well, and a knowledge of what community benefits, state benefits, and federal benefits might be out there for that person to take part in. I always have, every attorney has obviously a bunch of ethical duties to their client. One of the hardest things being an elder law attorney is determining who your client is. And so as you go to see an attorney, if you plan to be the client, just make sure that you engage in that conversation with them. Because if your son goes to the attorney and retains the attorney for information, that attorney may actually be representing your son. They may not be representing you. Maybe you come to conference number 2 to meet with that attorney, but if you're not that attorney's client, that attorney may in fact be representing your son, and you may find out, and you might find out a little too late, that that attorney represents your son and therefore is doing things in the son's best interest versus the parent's best interest. So be careful about who the client is and how that works and how you want that relationship to go. Sometimes it's better to have two attorneys, even if you're not fighting, just because you may have different interests. Your son may be much more interested in what you're leaving him than you are in what you're planning to leave him. My usual recommendation to my clients is enjoy what you've worked for, enjoy what you have saved for. Please don't just sit on it and leave it on to children or grandchildren who may or may not appreciate it. Enjoy it. So should you have a will? Everybody should have a will. Everybody that's over the age of 18 should have a will. You can go to any estate planning attorney and get a will. It just depends on what you want as far as advice and counseling around that will. A lot of times we're referred to as attorneys and counselors at law. I still use that old verbiage on my business card because a big part of what I do as an elder law attorney is the counseling part. I draft the documents and counsel you on those as well, but the other pieces that come into play as to how is this will actually going to be administered and what are your assets and how are those assets going to affect the beneficiaries that you're leaving it to is a big part of that. So you can go online and pull a form, you can go down to Staples and pull a standard form for a will, but that may or may not carry out your wishes. Because you won't know what you can add legally and what you can't add legally into that document. Last wills and testaments are very state specific. There's no such thing as a federal last will and testament. No federal documents. So if you have moved here from another state, you need to make sure that you see your attorney and that you have those documents reviewed to make sure that they are in fact valid in North Carolina. If you die without a will, you actually already have an estate plan. It's an estate plan that is the default proceeding out of the general statutes for North Carolina. So those people that you go vote for every November and send up to Raleigh, they've written your will for you. It's there. Probably doesn't do what you want it to do. Probably doesn't choose who you wanted to be in control of your estate. But there's a structure in those statutes called the Intestate Succession Act that say if I die without a will, where does my stuff go? So if that doesn't encourage you to get an estate plan done and get a will done, I probably am not going to convince you today to do that. Let's take an example. Let's say that you have a wife and you have two children, and those two children are from your wife. So you had that one marriage, had the two perfect children. Everybody has perfect children, right? And you die without a will. The assets that you own will only go 50% to your wife and 50% divided equally among your two children. So that a lot of times when we meet with clients, the majority of my clients who are married couples will say that they want everything to go to their spouse. But if you don't have a will leaving it to your spouse, the Intestate Succession Act will include your children. If it's a second marriage, if you have stepchildren, if you had children outside of that marriage, there's different ways to break down who inherits and who doesn't inherit. If you want to disinherit anybody, make sure that you have a will, because otherwise all those people in your bloodline will get a piece of your estate. It's not very personal for your family to deal with a set of statutes trying to figure out how to divide your property up. It's much nicer for families, at least the ones I've met with in my 27 years of doing this here, to actually have a will or a trust to look at and say, oh, look, Meemaw remembered me and she left me $5,000 to go towards my education. Or my spouse really did love me. He left me the boat and the lake house. So it's much more personal when you get to choose who you want to be in there. If you have personal property, so sometimes grandma will have jewelry that has been carried down through the family, or dad will have a watch or some famous golf clubs. It's really nice to leave those things directly to the people that enjoyed them. If the grandkids spent time with you in the summer and you always took them to golf camp here in Pinehurst, then it's really nice to kind of say, hey, you get my clubs, or, you know, you get my tennis racket. So make it personal. When you choose the person to be in charge of your estate, please think carefully about that person. If it's someone who procrastinates on everything, if it's someone who can't keep their own paperwork straight, if it's someone who can't balance their own checkbook, probably not a good person to be in charge of your estate. So don't just name your oldest child just because they're the oldest. You want to pick the person that's best for that job. If a personal representative is kind of the catch-all word for naming someone to take care of your estate. Some people still use the Latin executor, executrix. That's okay. If you don't have a will, you're called an administrator of an estate. So different terms really do have significant meanings, which is another concern sometimes when people just pick up will forms at Staples. You didn't have to go through 3 years of law school to know what the difference between those terms were. You also, if you die without a will, remember that there's no way for you to have left anything to friends or to charities or to things that were important to you, because the state statutes deal just with bloodline. If you have a will, there are specific terms that you need to understand the meaning of, or your attorney needs to understand. One of them is, the difference between executor, personal representative, and administrator. Those all have specific meanings. If I wanted to leave my jewelry to my daughters, I would bequeath my jewelry to my daughters because my jewelry is personal property. If I wanted to leave my rental house to my son, I would devise that property to my son. So you devise real estate and you bequeath personal property. Trustees, sometimes people have trusts in their wills, so maybe you want to leave something to your grandchildren, but you're not quite sure they're ready to handle that money appropriately, and you want to put it in a trust for someone else to manage. The person that you appoint to manage that money is going to be called your trustee, and they manage that trust based on the terms that you have put into your document for management and for conveying that property out. Everybody over the age of 18 who's competent, knows who they are, knows what they have and who they want it to go to, is able to make a will. When you sign a will, you need to be sure that you're in the room, 2 witnesses are in the room with you, and a notary's there. So there's got to be at least 4 of you there. You have 2 witnesses. Those witnesses cannot be related to you. They cannot be taking under your will at all. They can't be a beneficiary of your assets. And they have to be over 18 and be competent, know who they are. And then the notary watches all of you sign. So when she's notarizing that document, she's notarizing that you were there, that 2 witnesses were there, and then, of course, that she was there, of course, and watched all of that take place. Make sure you store your original will somewhere safe. We unfortunately see lost wills, and families delay probating estates and administering assets out to the beneficiaries because they don't have an original will to take to the courthouse to handle. You can put it in a safe deposit box. If you put it in a safe deposit box, make sure someone other than you can get in it, because once you die, we have a real problem getting you through the bank into your box. If you leave it with your attorney, that's fine. Some attorneys will store wills. Just make sure, you have like a receipt from them that says that they have your will and that it's in their vault. Attorneys are controlled by the North Carolina State Bar. And ethically, if we hold an original for a client, it belongs to the client. If that attorney gets hit by a truck and doesn't survive, then their office is required by law, and the state bar governs that, for you to pick your documents up. If you have it at home, just make sure, preferably, that it's somewhere not close to the hot water heater that might bust or next to the washing machine that might leak. And you want to be sure that it might be in a box or something you can carry with you if you know that your house is on fire, or something that will survive the fire, because you have to have the original to be recorded in the county clerk of court's office in which you die. Okay. Codicils to your will can be done relatively easily. A codicil is an amendment. That amendment has to be done with the same amount of legal formality as the original will. So don't ever mark on your original will any changes or what you want, because then you've destroyed the integrity of that original will. And if you want to make a change or amend it, you want to see the attorney and do an official amendment. A lot of times, if the client has done the will with me in my office, my preference usually is to just rerun the will for them with the changes. Because if you do a codicil, you still record that original will and then you record the codicils. Some of my clients have a lot of them. Some grandchildren don't thank their grandparents for gifts and they get taken out. So be careful. If you get a gift from somebody, do make sure that you thank them, because they may be in to see me to take you right back out. So your family would be able to read the history of what you've done. And if the point of amending it is because you are upset with someone, or you don't like your son-in-law, or you don't like your daughter-in-law, or a grandchild upset you because they got a tattoo or a piercing that you didn't approve of, and you're making a change, they're going to see that history if you do codicils. So sometimes it's better to just redo your will. Of course, you're deceased. If you don't care if there's controversy later for them to deal with, it's okay too. That might be your whole point. So the structure of a will is very important too. I've been dealing with a real estate transaction for months. Real estate becomes very entangled in estates. And so as a real estate practitioner as well, we are very often reading and interpreting wills or intestate files at the courthouse to determine how the title to that home or that land passed. I've been dealing with one for months that was actually drafted by an attorney, but in my opinion, very poorly. So the order in which the will is drafted and that you place your specific gifts versus the residual, everything that's left over, can be really important when someone else is reading that and trying to determine what it was that that person really wanted and what they wanted done, because who owns that real estate now? You want to do your specific gifts first. So let's say I want to do $5,000 to each grandchild. I want to give those specific things away. I want to leave my jewelry to my daughters and leave my son the rental house. So all those specific things are going to come first because we want them taken out of that estate off the top. Then you might have your residuary, which is, hey, whatever else is left after you pay my bills, pay my expenses, here's how I want it distributed. If you do want to make charitable gifts, those would be things that would be considered a specific gift. So if I wanted to leave $20,000 to the senior center to sponsor future educational programs, I could do that in my will. I just need to be sure that I do that specifically with a given amount or a percentage of my estate. When you do charities in your will, be very, very careful that you research that charity and that you direct the gift where you actually want it to go. So that example off the top of my head with the senior center, it would be very bad of me to actually leave $20,000 to the Moore County Senior Center, because that's part of Moore County's budget. Do I really want to give the county commissioners $20,000? That was not my plan. So I want to be very careful to leave it to an earmarked fund, a charitable nonprofit fund that would then be able to actually use it to put a speaker up here to do an educational program. Same is true for the zoo. The North Carolina Zoo is owned by the state of North Carolina. So if you write a will and you say, I'm leaving half of my estate to the zoo, you've left half of your estate to the legislators in Raleigh. It may or may not ever reach the zoo. More than likely will never reach the zoo. Who you leave your gift to is the North Carolina Zoological Foundation, which is the nonprofit entity that fully supports the North Carolina Zoo. So very particular in how you look things up and what you want that charity to use that money for. Conditional gifts, those are always fun. So the average client loves to come in and tell me about their perfect marriage and their perfect children. I'm very happy for them when I hear that, but I will tell you that most of the time I find an imperfect child, or another issue, maybe after they've passed away and those family members show up at my office, or when they hire separate counsel and we hear from multiple attorneys, you need to find an attorney that you're really comfortable with, because we really have a hard time representing you if we really don't know what we're in for, if we really don't know who you are and who your family is. So we greatly appreciate openness. If it's same for somebody who might be managing your money, you know, if you're scared to go visit with the guy that's managing your money, and sit down and talk about it, then you need to find a new money manager. So conditional gifts are, probably the oddest one I've ever done was I can't remember if it was a son-in-law or a daughter-in-law that the client really couldn't stand. So I think it was a third of their estate that was going to, let's say, to their daughter. And if she was still married to, or living with, or spending time with this current son-in-law, her gift lapsed and went to her siblings. So mom was basically saying, get divorced, get away from him, don't have any contact with him, and you get a piece of my estate. Little controlling, but I'm sure she had her reasons. So it happens. Sometimes we have serious issues, and we see it more and more nowadays with drug and alcohol addictions, and putting things into trust or putting conditions on somebody receiving their gift based on drug testing and attendance at Alcoholics Anonymous meetings and things of that sort. So you can do conditional gifts. A simple conditional gift would be that, if my daughter survives me, she receives my car. So there's a condition on it. She has to be alive to get my car. But they can get much more complex than that. We also put a number of trusts into wills. If you have a trust inside your will, it's called a testamentary trust versus a separate self-standing trust. So if you have reasons, and a lot of people do, and that's fine, this is your money, these are your assets, you have reasons to not want to gift them directly to the beneficiary, you can put it in a trust, and then you come up with the terms of the trust. So using myself as an example, my husband and I have 3 children. We have survived. They're now 3 teenagers. So we would not leave our assets directly to minor children, or to, a 19-year-old to manage. That would make my daughters attractive to probably the wrong kind of gentleman that I wouldn't want in their life if they had our assets and we were both gone. It could also discourage them from higher education or discourage them from working hard. So a lot of times parents will put those assets into a trust, name a trustee to manage them so they're not just stuck somewhere. The rental property would still produce rent. The brokerage account would still be well managed, but the trustee would have maybe discretionary authority to distribute funds. So I have a daughter that plays basketball and maybe she needs some money to go to a basketball camp. My son's an entrepreneur and just opened a store in Southern Pines, and maybe he needed a loan to pay his workers' comp insurance or something else. And so that trustee could sort of stand in my shoes as the parent and make those decisions about the distribution of money. And then I might have an age, or I might have a condition where I tell the trustee to go ahead and release those funds to my children. Sometimes, let's say I live 20 more years and the kids are in their 40s, then maybe I just want it to go outright to them. Or maybe I don't like who they've chosen as their life partner and I want to keep things in trust so that greedy son-in-law or that daughter-in-law that I can't stand doesn't have access to those funds, that they remain inherited funds in a trust. You might have a child that's a spendthrift, as we call it, that just doesn't know the value of $1, and the minute you give them one, it's gone. That's another reason that we create trusts for folks inside of wills so that they become effective at my death and they get funded with my assets. I already said to make sure that you are comfortable with who you've chosen as the representative or executor of your will. You always want to name alternates. That person may be unable to jump in and take over an estate at the time that you pass. They may predecease you. They may develop dementia, Alzheimer's, or another illness where they can't serve as the representative. I push my clients to give me a list of 3. Who's your primary and who are these 2 backups? It's not really fun to go in and have to do estate planning. It's not fun to call and make an appointment with an attorney. We know that. We have tough skin. So I want you to have a will that lasts a long time. I don't want you to lose your spouse and have such a simple will that you immediately have to come and sit in my conference room and think about what you want to do with everything that's now yours. I would much prefer that you have a will that says, everything to my spouse, but if my spouse doesn't survive me, here's what you need to do with it. So think longer term if you can. Do I want a will, or do I want a trust, or do I want both? So when I say trust, I'm referring to what people call a living trust or a revocable trust. That is a trust that you set up during your lifetime and hopefully fund during your lifetime if you have one. And you could be the trustee and you could be the beneficiary of it. Why would I want to do that? In my opinion, there's 2 reasons. One reason is that you want privacy. So if I die tomorrow, my will go on record at the clerk of court's office. If I have really nosy neighbors or somebody that just wants to go to the courthouse and read my will, they can technically go and see the estates department and ask them to pull the file, and they can flip through my will. I really don't have anything that exciting in my life that I think you guys would run up there to read my will. So for me, that's not a concern. I see wills a lot of times in Rockefellers, Kennedys, Trumps, Clintons. Those families usually all have wills because they don't want the details to be published in the New York Times. But if privacy is important to you, if there are assets that you have that you don't want people to know that you have, or there are illegitimate children or more marriages than your friends in Pinehurst know about, or other things that have gone on in your life, then you're more than welcome to have a trust for privacy purposes. The other reason is to avoid probate. And if you're a late night TV watcher and you watch the Susie Ormans of the world, they will convince you that everybody has to have a trust. Make sure that you're counseled about whether you want or need a trust and that you understand how to use that trust. I see a lot of beautiful binders that people have paid a lot of money for to have trusts created. And when that person passes, or even if they come to see me for a will review, they haven't put anything in the trust. They haven't retitled any of their accounts. They haven't deeded their property. They're not doing anything with the trust. So you have this, somewhat expensive, beautiful document, may say exactly what you want it to have, but you haven't moved anything in it. So that means that everything's going to come through your will, and your will is going to be a pour over will, which means that everything comes through the will and it says, dump it into my trust. So now I have your family in front of me and we're doing the full will administration, but we can't give them anything from the will because we have to finish this and dump it all over into the trust. And then we have to administer the trust. So I'm good with people having trusts. I'm not terribly antitrust. I just want you to have a reason that you need one, and I want you to understand it enough that you're actually using it and funding it so that you're getting a benefit out of it. Living trusts do not save taxes. They don't help you apply for Medicaid, veterans benefits, or any other benefit program that I'm aware of. So there's a lot of misinformation about revocable or living trusts protecting you for that purpose. So do you want to avoid probate? So what is probate? Probate is the recording of your will and the local clerk of court's office certifying that your will is valid. So they review it. They make sure that there's proper witnessing, there's proper notarizing, and then they file what's called a certificate of probate that says, yes, your will is good here, it's valid, this is how your assets are going to pass. Then I call it an audit. If you've ever been through an audit in business, I hope you haven't been through one with the IRS, but it's much the same. They're just going to look over and make sure that the terms of your will are carried out. So if I die next week and my will gets filed, they're going to be sure that my husband has transferred everything to himself as the beneficiary, and that he's paid the funeral bill and he's paid any attorney's fees. And they're going to look for certain procedural things that he's done to make sure that my property has passed correctly. Then you file what's called a 90-day inventory with the clerk of court. So if my husband was administering my estate, he would come back to the court with what's called the 90-day inventory and say, here's what I found. And this is what's going to pass through her will. And then hopefully within a year or less, he's done the paperwork to make sure that everything transferred to him, and he files a final accounting and says, I'm done. We went to the CPA. We did our final joint return. We got the tax refund. I've paid all of her medical bills. You know, we've canceled her credit cards. Everybody's been paid. We transferred her car title, and we're finished. And then if he was the only beneficiary, he wouldn't need anything else. Maybe I did a codicil and left my daughter a car and, you know, left my son something. And if I had done that, then they would just sign a receipt saying I got what I was supposed to get from mom's will. So that's kind of the probate process. So you pay $120 to open an estate. You have to run the creditor's notice in the local paper, which is just the pilot for us twice a week. So that has to run 4 times. And when you run that creditor's notice, that costs about $200. So you got $120 to open. You've got about $200 you'll pay out to the pilot. And then when you file your 90-day inventory and you show what you actually have in your estate that's passing under your will, they assess a fee of $4 per $1,000 of value. And the things that pass through your estate are determined by law. So if I had a joint account with my husband, that's not part of my will because that was a joint account. When we signed at the bank, we said it went to the survivor. If we own some real estate together, under North Carolina law, the deed to that property being in both names automatically belongs to the surviving spouse. If I have a retirement plan and I've named him as the beneficiary, that's also going directly to him. So none of those assets have fees or anything collected on them. Maybe I had an individual checking account that I had put some inheritance from my granddad in. And if that account was in my name alone and I didn't have a beneficiary on it, that would be something that flowed through my will. My car title's in my name alone, so my car would flow through my will. So you have to look at your assets and how you have them registered to figure out what would be in a trust and what would flow through my will and what would the difference in the expense be. If it comes out at the end that it's better for you to have a trust, I always like my clients to have trusts if they have property in multiple states, because we don't want to do an estate administration in multiple states. We prefer, of course, to do that once and be done. You don't want the expense of other states. Some other states have very, very punitive probate processes. Florida, New York, I heard a nightmare about Ohio this week, California. Those are all kind of the ones that Susie Orman and her gang are very spot on that you ought to have a trust. Those are very complex states to probate a will and administer an estate. They require attorneys. And so it's just a person by person analysis as to whether a trust is a good thing or not, in my opinion. You can revoke a trust, a living trust, revocable trust, and you can amend it. And of course, you're going to name trustees. So if I have a trust, I would appoint myself as the trustee to take care of everything while I'm capable. But if I develop dementia, or I was injured or suffered a stroke or passed away, then I would have my alternate trustees named to jump in and take over. And my trust would tell them how to pay my bills and handle everything for me. And if I had died, how to disperse my assets out. There are other types of trusts. Irrevocable trust, that means you can't revoke it, you can't amend it, you can't change it. Some people do those types of trusts to preserve maybe a family beach house or a family farm where you don't want that to be an available asset for your end of life care, sort of a Medicaid asset protection trust. People just have to understand that whatever you put in there, you can't get back and you can't change the terms. So you just have to be comfortable with executing those types of documents. Some people have irrevocable life insurance trusts. When the estate tax, I started practicing in 94, the estate tax limit was $600,000. And so if I died and I had more than $600,000 and left my estate to my children, they had to pay estate tax on everything over $600,000. So what I might have done back in that day was purchase a life insurance policy that would basically either pay the tax for them or replace the assets that they lost because of the tax. Today, North Carolina has no estate tax, no inheritance tax, and no gift tax. Great choice to live here, especially for your kids, because you can give it all away to them without them paying any tax on it. The federal government still has an estate and gift tax system. It's still a combined system. So I always think of it as a little ledger up there at the IRS for me. And that ledger currently says that I have an opportunity to give away $12,070,000 to any one of my choosing. Feel free to sign up. I don't have $12 million to leave you though. And I can do that during my lifetime, or I can do that when I pass. And so that's why it's a combined estate and gift tax system. If I overgift, I have to file gift tax returns and use part of my credit on my ledger. If I never make a gift that exceeds the gifting limits, then I've never used my exemption at all. And I can die with $12,070,000 and not pay a federal estate tax. The current gift tax limit is $16,000 still this year, right, Penny? Okay, I see a CPA in the audience, so make sure I get my tax law right. So I can give $16,000 away every year to anybody of my choosing and not have to file a federal gift tax return. But if I mess up and I give my kids $16,000 checks and I also give them a sweater for Christmas and I also take them to a club for dinner, then I've exceeded $16,000. So I personally tell my clients, don't ever write checks for exactly $16,000 because you're just waving a red flag in front of the IRS and asking them to dig a little bit deeper. So maybe give those kids $14,000 and then still remember them on their birthday and Christmas with something extra, or take them on vacation and cover some of that bill. If I gave my children $17,000, I would need to file a federal gift tax return. When I filed the federal gift tax return, I would have to report that all three of my children received a check for $17,000. I was allowed to give them 16, so I had $1,000 extra for the three of them, and I needed to use $3,000 of my credit on my ledger at the IRS. Now in 2025, federal estate tax is scheduled to go back to the 2017 number, which was 5.6 million, and indexed for inflation from 2017 to 2025. So that's roughly half of whatever it is in 2025 would be the new number. We all know that most of our politicians like to return to Washington. So my guess is if they want to be reelected, they probably will not let 2025 roll around without addressing that again. And so you just need to watch for any federal estate tax changes. The Biden tax plan is currently written, but not in a current bill being studied up there in Washington, says that they'd like to take the estate tax back to $3.5 million. If they take it back to $3.5 million, obviously there'll be a lot more people paying estate tax. You have a credit and your spouse has a credit. There's something called portability. They've left that in the law for now. So if the Biden tax plan passed and I had $3.5 million ledger, I just instantly, poof, have lost my $12,070,000. It gets replaced with $3.5. And if I had $5 million, I wish, if I had $5 million, my husband also has a $3.5 million credit. So we could still work on our estate together and leave our children $7 million without a tax. We just have to make sure we file the right documents to preserve that credit from the spouse. If you remarry after you lose your primary spouse whose credit you've taken, you also lose that credit. So be careful about that. Let's talk about health care benefits. So, well, no, let's not. Let's talk about power of attorney first. I'm skipping over stuff. Okay. So let's go from will to power of attorney for financial matters, because you've already died. Now we're bringing you back, and we're going to talk about all the great things you should have before you die. So one of those is a financial power of attorney. We want that financial power of attorney to be durable. Most every power of attorney that gets drafted is in fact durable, but not all. It just depends on the special language. What durable means is that when I sign a financial power of attorney for my husband to act for me, I want him to be able to act even if I lose my capacity. So maybe I want him to act now because I'm going to take a month's vacation and go live in Tahiti for a month, and I want him to deal with all the bills. So I'm competent, but I don't want to deal with bills and tax returns, so I give him a power of attorney. On the way back from Tahiti, I get into a car accident. On my way home from the airport, and I'm left incapacitated. I want that power of attorney to continue because I want him to be able to take care of me and the children and be able to handle my finances. So I would want a durable power of attorney to work in both circumstances. Please be sure that you pick people to be your agent or your attorney in fact that balance their checkbooks, understand finances, understand bills, insurance, all of that, because they need to just completely jump into your shoes and be able to kind of run with your life and keep things straight for you, whether it's temporary or whether they're doing that for the rest of your life for you. I see a lot of clients, and this is kind of where the estate planning merges with the elder law a little bit, and we need to thoroughly discuss gifting provisions, because if you're not competent to come back in and see me in 15 years when you need to go into a nursing facility and your family's trying to figure out how to pay for it, we may have to move some assets around. Now, remember, those programs are complicated and we can't just willy-nilly gift assets, but there are exceptions. For example, if I had a disabled child, I could make gifts to my disabled child in an unlimited amount and still qualify myself for the government benefit called Medicaid, which covers my nursing home care. But if I don't have a gifting provision built into my financial power of attorney to allow that person to make those transfers and those gifts to my disabled child, there's nothing they can do to get me qualified for the benefit short of spending my money down. There is a proceeding where you can actually petition the clerk of court to approve a gift, but you have to do a whole court case to basically see whether you win or not and have the opportunity to make a gift. And it's in the discretion of the clerk of court. I talk to my clients a lot about gifting provisions, whether it's for tax purposes, so they can give away that $16,000 a year to reduce the size of their estate because their estate is too large and they're going to face estate taxes. Also talk about income tax. If you're getting kicked into the next bracket because of required minimum distributions on your IRA or your accounts are just doing really well, sometimes we talk about gifting some assets out of your name so that we can reduce the size of the income tax that you're paying every year. And then we also talk, of course, about gifting for government benefits like veterans planning or Medicaid planning, where we have to reduce your income or reduce your assets to get you qualified. Some people want to be able to make gifts for medical purposes or educational purposes to people. I meet some grandparents who are funding grandchildren's education, for example. And if grandma had a stroke and couldn't physically write that check to the institution and they wanted that to be continued, they need to give that specific ability to their financial power of attorney to make sure they can write that check to pay for that tuition. In my case, when my children reach the age of 18, we have offered to assist them with furthering their education and those expenses. Well, when they turn 18, believe it or not, under the law, we don't have to take care of them anymore. I do try to remind them of that at their teen years, as I'm sure you all did as well. But most of us as parents are kind of softies. They are the kids after all, and we help them after 18. But legally, we don't have to pay anything for them after they reach the age of 18. So if you have children or you're talking to your children about getting their planning up to date, think about those grandkids, and you may want them to be able to be taken care of after the age of 18. How do you execute a financial power of attorney? It only by law has to be you and a notary in the same room. So they have to be notarized. I actually do 2 witnesses and a notary in my office. Number one, just because we're usually doing a will at the same time and they're in the room with us. But there are states that do require witnesses and there are states that require notaries. So I figure, why not have all of them on there? And then if my client moves to Florida, their power of attorney is still going to work because Florida likes it to have those 2 witnesses and a notary. You don't have to file your financial power of attorney at the Register of Deeds office any longer, except for real estate transactions. However, that's a relatively new law. And most financial institutions do not know about that and have not updated their manual. So for practical purposes, if your agent needs to go into BB&T, now Truist, or go into Bank of America and make a deposit for you, write a check for you, get added to the account as your financial power of attorney, they need to make sure that it's been recorded, because if they don't see that cute little sticker from the Register of Deeds office in the top right-hand corner, they're going to turn your agent around and try to give them directions to Carthage to record that. I don't recommend that my clients record their financial powers of attorney early unless they choose to, because if it's not recorded, you can revoke it, you can amend it, you may never need it. You know, if you die in a car wreck or have a severe heart attack and you don't survive it, you never needed your financial power of attorney. So you don't really have to clutter the record by filing all of them. If you record it and then you do want to revoke it, you have to file a revocation. So if it's of record, you need to make sure you revoke it of record so people know that it's no longer effective. So if you tend to change things or have family drama or, appoint a friend, but your friend is 5 years older than you and you think, oh, I might need to amend that, then you probably don't want to run to the Register of Deeds and record it, because you'll just have to record a revocation later. Guardianship is the alternative to doing a power of attorney. So earlier, when I advised you that you really do have a will in the general statutes, and you may want to rethink that, another part that's a little bit scary to encourage people to plan is if you have a financial power of attorney, that's wonderful. If you don't, and you become incapacitated, incompetent, develop dementia, have a stroke, anything that keeps you from doing everything for yourself, the only option your family has is to do guardianship for you. I'm glad we have guardianship and we have guardianship statutes, because there are a lot of people that don't plan or have old documents where nobody is named that is still alive or can take care of them. But it is a very stressful and very complex process. What that means is that you're going before either a jury of 12 or the clerk of court, whichever your attorney feels is most important, and they are declaring you to be incompetent. Very stressful for your family, very stressful for the people that care about you, very stressful for you. Whether you understand what's happening or not, hopefully you would not. It's horrible when people understand it, but are still found incompetent because they really don't have enough ability. They have enough to be stressed and upset and anxious, and it's heart-wrenching, but they really don't have enough to remember to take their meds or to be moved into a safer location, or they refuse to leave their home, but they continue to leave the stove on and visit the neighbors at 3 a.m. and some of the other things that happen, they'll be found incompetent under the law, which means all of their rights to do anything for themselves go away. And then the clerk of court's job is to appoint a guardian. That might be someone you know, that might be someone related to you, or it may be a stranger that you've never met before. And so I do highly encourage you to do your own planning and pick those people in your financial power of attorney that you would prefer to take care of you. Stressful and expensive to not do that planning. Same goes for the healthcare power of attorney. Let's say that you're unconscious after a car accident or a wonderful traffic circle, and nobody knows what to do with you. No one knows what decisions to make. No one has been given the power to make decisions. That could be another situation where you have a guardian of the person appointed, and the guardian of the person is like a healthcare power of attorney where they have the right to make those decisions, decide where you're going to move into, pick a nursing home, pick an assisted living for you. You want to have healthcare power of attorney if at all possible. So here's the default. If I didn't have a healthcare power of attorney and I had an accident at the traffic circle this afternoon and I was over at First Health in the emergency room, I broke my pelvis and they had to give me a bunch of morphine to keep me comfortable and happy. I really shouldn't be talking to the doctor and making decisions at that point, right? So I'm out of my mind. I'm very comfortable and very happy. And I shouldn't be signing my surgical release for myself. So if I have a healthcare power of attorney on record, which I do, it's my husband. My husband should come and make those decisions. My husband's an airline pilot. He may be unreachable. That happens about 50% of our life. So if he's unreachable, it's my brother. And my brother should come and make that decision for me. But what if I was there and I didn't have a healthcare power of attorney? So it would default to my husband because he is listed in the statutes as a spouse who can make that decision. If he's unavailable, it goes to my next degree of kinship. Okay, so then you got to look at your little family tree with our little North Carolina word kinship in it and figure out who do I have available. So in my case, I've got children, so we're going down the branches of the tree. But I have two that are 18 or over. Those two have to work together because they have equal standing and have to make a decision for me. That might work out beautifully. And that might turn into World War III over at First Health. You know, only you know what your kids would do, right? And then in my thinking, are my kids at 18 really able to make those types of decisions? Do they want to make the decision about what to do with mom when they're just now becoming adults? And then how does my 16-year-old feel? She's not old enough to be named or included, but I promise you, Miss Emma has a lot of opinions. And Emma is always right. So we would really probably have World War III over at First Health. So you won't read it in the pilot. I have a healthcare power of attorney. But that's kind of the natural. So if I had no children, it would start going back up the tree. So they would have to go to my parents. And I'm lucky. I'm so lucky. My parents are both alive and they live here in Pinehurst and I get to see them all the time. So they would come over. The reason I named my brother as my healthcare agent, though, is because my mom was a nurse. My mom was an end-of-life nurse, just recently retired. Awesome nurse, great with end-of-life patients. But I'm her daughter, and she's an awesome mom. So what would happen if she got called to come make a healthcare decision, and Jennifer, her oldest child, was laying in a bed hooked up to machines? Mom would have a very emotional difficult time pulling the plug, in my opinion. So I skipped over her and went to my very hard-nosed, matter-of-fact brother who would walk in and pull my plug for me. So you got to think through. You need to pull these personalities and think about these people before you just list them. You don't want to list them just because they're a relative or just because they're the oldest. If you want your plug pulled, make sure you pick that person that'll come and do it for you. So if they went back up my family tree, they could grab my parents. If my parents couldn't make that decision for me because they were out of town, because they had passed away, because it was just emotionally difficult, they'd go looking for the siblings. And so for some of you, I know it's very difficult to make that family tree And it might be even more difficult to imagine those people being there making your decision for you. So when you sign a healthcare power of attorney and give someone that power, got to have 2 witnesses and a notary. So we're back to those 4 people in the room again. We have to fill those conference rooms up. Those 2 witnesses can't be related to you because they might be ready to inherit, and that would make them a plug puller, and maybe you don't want the plug pulled. You also don't want the emotional one who won't let you go. So think about who they are, but those 2 witnesses need to be disinterested. So they can't be related to you, and they also can't be employed by a healthcare facility. So you really don't want to wait until you're in the emergency room at First Health and say, you know what, I want to sign a healthcare power of attorney. It's very hard to find 2 witnesses and a notary when you're already in the hospital. First Health is great. They do have notaries on staff, and they'll let you use the notaries, but they're prohibited by law from any healthcare employed person from being a witness. So you got to run around to the waiting rooms and try to find folks if you wait till the end to sign those. Make sure you name alternates. Again, we want that long-lasting document. So I kind of already gave you that scenario where my husband's name, but he's off in an airplane, and my brother travels for work. Maybe they won't get him, and I don't even remember who my third one was. But so I've got at least 3, and I recommend to my clients that you have at least 3. What good is yes, ma'am. Can you amend a healthcare power of attorney? So to repeat the question, if you have your spouse named and a spouse has passed away, then you have just one child named to make a decision and no one after that. Should you update or amend your document to include more alternates? My answer is definitely yes. Which is why I try to push people to do 3 from the beginning, just so we have a longer lasting document. You can amend a healthcare power of attorney, but it has to be amended with the same stipulations as a new healthcare power of attorney would need to be done, the 2 witnesses and the notary. So I've actually got a case. One of the fires I was putting out before I got here this morning was a client trying to get admitted to hospice, and it was a healthcare power of attorney working with hospice people to try to get him admitted. And I had not heard from the client in a while. Well, come to find out, they've been working for weeks and weeks trying to get this healthcare power of attorney recognized by this hospice group I hadn't worked with much in the past. And I don't know, they just weren't reading the amendment. So we had done an amendment for that client because he was older and he was having some health issues, and it was just kind of easier to stick to that 1-page document and amend it. And I don't know if they weren't looking at the amendment or they didn't understand that it could be amended, but there was a legal glitch. So I kind of encourage, if your attorney still has it in their computer, and you can call and say, hey, bump my husband out, move my daughter up, and slide somebody else in there for me, and I can come by at your convenience and sign, grab all your witnesses. I would just start fresh, in all honesty, because you still have to distribute that new document just like you would have to distribute your amendment. So what good are those documents going to do if they're at home in my desk drawer? They're not going to do any good, right? So you want to distribute those healthcare powers of attorney. So here's my rule. Here's my speech. If you were in my office and you just finished signing those healthcare documents, we would send one to medical records at First Health Moore Regional Hospital for you, unless you ask us not to. We would send one to your primary care physician, unless you ask us not to. We would send one home with you. We would send one with you to give to each of your alternates. And we would make one for you to place in the glove box of your car. So those alternates need to know that they're named, and they need to know what order they're named in, and they need to know what you want and what you don't want. The hospital needs to know if you have documents. If you don't have a file at the hospital, that's wonderful, and I hope you don't ever need one, but they will still accept your documents and set it all up for you. Your primary care doctor should have a discussion with you about what you want and what you don't want. if you're ill or if you're nearing the end of your life. So I love for my clients to personally take it to the primary care physician during one of their annual checkups when you have more than 3 minutes with your doctor, and hand that to him and have that discussion so that they've documented it. If I suffered a heart attack, and that's why I had my accident at the traffic circle, and I get put in Reed Heart Center, my family physician's not going to be coming over and doing everything because they're not a cardiologist. I'm going to have a cardiologist, but that cardiologist is going to be reaching out to my primary care doctor, and the hospitalists that come around and see you in the hospital are going to be sending notes to my primary care. So you still want your primary care in the loop. Hoping that you recover well and get back to see them. Yes, ma'am. The copies that you distribute can be photocopies. The law specifically says that your healthcare documents in North Carolina can be copies, and they are just as effective as the originals. So you only need one original. If you make changes, if you make amendments, make sure that those copies go to all of the same places and they understand that you've made a change. First Health will mail you a letter after they receive your documents acknowledging receipt and letting you know that it has in fact been placed in your medical record. And you can keep that with your copies so you remember that you did that part. You can revoke it. As long as you're competent and capable, you can orally revoke it. So if I was awake and I'm in the hospital and they haven't given me the morphine yet, and I say, you know what, I don't want my brother to make a decision for me, I'm revoking my healthcare power of attorney, that is effective. But I need to make sure that when I'm up and running again, I don't really run, you can probably tell, but if I'm up and running again, that I go and gather all those copies up because I've revoked that document. I wouldn't want it to go into effect again. It does only take effect if I'm not capable of making decisions. So you don't have to worry about making your own decisions. It's only when the doctor says, you know, I think we over-medicated her. We probably should get someone else to sign. The other important thing that's in that healthcare power of attorney, I am not a huge fan of the standard document that pops out of the statutes. It works, it's legal, it's so much better than nothing. But I do add a lot of verbiage into mine for my clients personally, and your attorney may do the same as well. So read it carefully, read it with a red pen, make sure it says what you want it to say and that you've made your own decisions. Don't just default to the standard language. You should address organ donation within that document, whether you want to be an organ donor or you prohibit anybody from donating your organs. You should address body donation. Can they donate your body for anatomical study or research programs, or are they prohibited? You should discuss cremation. You should discuss burial. You should discuss what you want and what you don't want. If you want your cremated remains sprinkled around the back of the senior center because you have loved all of your time here today, that's not legal, so don't type that in. But you might have a good friend that'll come do it for you anyway, okay? I promise you don't play golf alone in Pinehurst. Yes, ma'am. I'm familiar with 5 wishes. I'll talk about 5 wishes in a minute. And thank you for bringing it up. Make sure you discuss end of life and where you want to be. So if you want to be home and you want to have home caregivers come in, hospice come in as support, make sure that that's clear. If you're uncomfortable about being at home or feel like you don't have a support system to put that in place for you, then be very clear that you're comfortable and that you're okay with your children choosing to place you in a facility. Okay? Okay. It is recorded though, so be careful. Yeah. Oh yeah. Okay. Thanks, Steve. So yes, if you have legal documents that say one thing and then you have your driver's license that says another, it would be a conflict, but I will tell you that the rather new law about organ donation officially being on your driver's license, and everybody feel free to whip yours out, but if you have the little red heart, you have told DMV that you're an organ donor. That statutorily is your decision. And so I've got the red heart. They have the right to donate my organs. They don't even have to ask my family or talk to my healthcare agent. So it's a conflict, but technically that driver's license decision, and who in the world thought that while you were down at DMV studying all the signs and trying to make sure you remembered which one was a railroad crossing, that it was a good time to talk about donating your organs? I don't know. But whatever you decided down there is legally what controls now in North Carolina. Practically what happens? Practically, I've never had a client donate organs without family consent. So from a practical standpoint, I think the organ procurement folks are very careful about making sure that family actually knows what's happening and they don't want to be sued. So that may be something you want to clarify, definitely. And if they're from out of state, you want to get them looked at anyway. So all those doctors over at First Health and your family doctor, they're all governed by North Carolina law. What they have is a North Carolina medical license. If you go to St. Joe's Health Center or Quail Haven at the inn, you go up to Terra Plantation or Magnolia Gardens, those are all regulated facilities. They're either regulated by the feds or regulated by the state. They all have a North Carolina license to operate. So if you want your documents to be effective and you want your documents to be honored, I highly encourage North Carolina documents because they know what they're supposed to say and they know that they're protected. So if I want the plug pulled, I really don't want to have to be plugged in while First Health and their attorneys look at my healthcare power of attorney from Maryland to try to decide if my plug can be pulled. Okay. So let me address the question about the 5 wishes document. For years and years, the 5 wishes document, which you can purchase online, did not meet North Carolina standards to be a healthcare power of attorney and a living will. So be very careful if you use that form, where you got it from and whether it meets the statute. I personally love the 5 wishes form, but I do not love it for the replacement of a healthcare power of attorney and a living will. And that relates to my comments earlier about the doctors and the facilities. They're busy, folks. They're understaffed. They've got a lot of people to take care of, and their license is very important to them, as it should be. They really don't want to read what kind of music you want playing in the background as you're leaving this world. But you know what? Your family does, and that's really important. So I really like my clients to use the 5 wishes as a guide and as something that they leave for their family, that they copy for their family, that they share with their loved ones. But I don't really like it to replace the standard documents that the facilities are used to seeing, because I am afraid that it causes delay, and it's a lot to read. And the doctor doesn't need to know what psalm you want read at your service. I'm sorry, you might think he does, but he really doesn't. That doesn't affect his medical decision about you. So they're very, very important, but I personally, it's just my personal opinion. Your attorney might love it. These are just my comments today. They are not legal advice for you. So use that as you wish. Yes, ma'am. So there is a booklet that you can get from the clerk of court's office about probate and what to follow and how you administer a will. I don't necessarily think that it's anything that anybody needs to look at or read prior to someone passing. What happens when they pass happens when they pass, and you really can't do anything until you get a death certificate anyway. And so you've got days to kind of wait for all of that to be processed where you could review that. But there is a little book from the North Carolina Administrative Office of the Courts. It might even be online that you can just download and print it. It's just not specific to mother-in-law and her assets and her estate. The funeral homes are also pretty good about giving you a packet when they give you your bill and your receipt for payment about what to do next. And there's some good information in there, but again, remember that it is extremely general and a lot of it doesn't apply to the different estates that we handle. So we see people in a panic. Today's day 29. This booklet says I have to be at the courthouse on day 30. I don't know where to go. I don't know what to do. I can't find the will. We take a lot of those crisis calls in my office and we go, okay, breathe. It's okay. There's actually no law that says you have to get there within 30 days. It's just in the funeral home book. So go relax. Your son wants to take you to the beach for a week. Please go to the beach with your son for a week. The will's still going to be there when you get back. So there are some time requirements, but for the most part, you could grieve the way that you need to grieve. And then, you know, in some people, it's business day too. Let's go. And there's nothing wrong with that. We all grieve differently. Part of the worst part of grieving is that people tell you how to do it. And that's really wrong. They shouldn't tell you how to grieve. So I can't say enough about the grief counselors at First Health Hospice, by the way, just to give them a little plug. Great folks, and your loved one doesn't have to be a hospice patient to even use their grief counseling services. That's part of what's covered by a lot of the generous donors in our community who support First Health Hospice. Foundation. A lot of talking. One document I want to make sure I don't miss. So I talked about pulling the plug and having my healthcare agent do that for me. My healthcare agent is my advocate. That's my person. That's my right-hand man that I said, hey, here's what I want you to do for me. Here's what I believe in. Here's what I don't believe in. Very personal. Needs to be your decision. I'm just using myself as an example to get my point across to you guys. So I'm a pull the plug person. I don't want to lay around if two doctors have decided that I'm terminal and incurable and I only have a short period of time to live. Or if I'm unconscious and I'm not expected to regain my consciousness. We used to call that the vegetative state, but apparently that was politically incorrect, that we were calling, that we were picking on vegetables. So for the cucumbers and the squash, we no longer say that. We have this big long verbiage about being unconscious and not waking up. And then they added a third category for us in 2007, which has been kind of nice because we see the aging of America, which is just happening really, really fast. And we have to deal with end-of-life issues more and more, and we're dealing with dementia more and more. So dementia is this huge umbrella. Alzheimer's is one of those little tiny things underneath that umbrella. So we got about 88, 89, might be 90 today, different versions of dementia. But it happens. As we age, our brains age as well. So we used to say grandma had hardening of the arteries. Well, it's probably vascular dementia, right? Same thing. It's not new, but we have a lot more of it because we have a lot more people living a lot longer. When we talk about dementia, it's terminal, it's incurable in 99% of the cases. So it technically meets that definition, but they did a separate paragraph for us that says that if we have advanced dementia, and we have lost a substantial amount of our cognitive ability, so we're not thinking, we're not processing, we're not connecting things together, then we also have the right as North Carolina residents to decide that we do not want our life prolonged artificially. So that's kind of the third category. I feel comfortable that it was covered in the old documents. So if your documents are pre-2007, you should be fine because it's a terminal and incurable illness. Might end up in a vegetative state at the end of it. So I feel like it's covered in your document, but it is a good exercise to go through in making decisions in that circumstance as well. So if, you sure? Okay, your memory's better than mine. All right. So if two doctors decide that I'm terminal and incurable, vegetative state, or have lost my cognitive ability, I get to choose whether I direct them that they may withhold or withdraw life-prolonging measures, or they shall withhold or withdraw life-prolonging measures. So difference between the word may and the word shall. If you have children, you understand the difference. Shall is a command. So when that little guy runs across your white carpet with his muddy shoes, he shall go to his room right now. When he runs across the carpet with muddy shoes, you usually don't go, well, you may go to your room because I don't really want to clean the carpet again. So may is discretionary, shall is a command. You choose one of those. Then if you believe that you would like to have artificial nutrition and artificial hydration, which by law in North Carolina are considered life prolonging, it gives you the opportunity to opt back in and ask for artificial nutrition, artificial hydration, or both. Then you make one very, very important decision in the new healthcare or the new Living Will Declaration of Desire for Natural Death, new being 2007. We still call that new in the law. You get to decide whether you want your healthcare agent to be able to override all those decisions you already made, or whether you want your healthcare agent to follow your instructions. And so that didn't exist in the prior law. So you had a living will and you had a healthcare agent, and the doctor stood there and went, ooh, which one do I want to do? Well, you're unconscious and you can't argue with him or sue him anymore. So he's probably going to listen to your healthcare agent. But now you get to make the decision in the 2007 after living will. Okay. Again, same distribution list. This is part of your healthcare documents. So get those distributed. You can always revoke it. You can always amend it. You can always change it. And I want to touch on DNRs and most forms because I get a lot of questions about those, but you want to wrap back around with your question on that one? Oh, okay. Okay, so for those of you watching at home and those of you that may not have heard that, so an experience in the hospital had a DNR in her file, and then Nurse Ratchet, who I'm sorry she had to meet, but we do have a few of them here, most of them not, but some of them find us, asked if she wanted to be revived or not, and left that decision kind of up to her again at 2 a.m, probably not the best time to ask you. So your living will, the document that I just went over, the Declaration of Desire for Natural Death under North Carolina law, requires 2 doctors to first determine that you're in one of those awful conditions before that kicks in. So technically that living will, Declaration of Desire for Natural Death, is not a do not resuscitate. So a do not resuscitate should have been a separate order signed by a doctor. And I meant to bring my little prop with me today. It's a copy of a DNR, but it's a bright yellow sheet of paper, 8.5 by 11. Or actually, yeah, it is 8.5 by 11. And that has a red stop sign right in the middle of it. And it says, I do not wish to be resuscitated. And it has to be signed by your doctor and dated. That do not resuscitate overrides everything else in regards to your health care for being resuscitated. So if you have a DNR, yes, you can always revoke it, but it is a doctor's order to not resuscitate you. And we have a lady in the audience who has one. Yes. So big red stop sign used to be in the middle. Looks like it's on the top left now. That should be in your hospital records. And if you're home, it goes on the refrigerator. If you're in a hospice bed at home where you're not moving around at all, they can just put it on the headboard for you. So let me tell you what that does. That is not a document that I or any other attorney can do for you unless we also have a medical license. It is a doctor's order. It is just like a prescription tablet that he has in his office, and he can write you a prescription for not being resuscitated. You have to have the original. The original has to be with you when the event occurs, and that is the only way that it is effective. I have a lot of clients who are nearing the end of their life or feel like their quality of life is not what it used to be, or are just kind of tired. And if God comes and gives me that massive heart attack, then they're okay with going. They should have a do not resuscitate. And here's why. I collapse right now, and one of you nice folks calls 911. That beautiful Moore County bus comes to get me. When those guys run in here with that stretcher and all their bags, they, by law, have got to resuscitate me, and they have to stabilize me. So you wonderful people get to watch a little extra show. Then they take me in the ambulance and they get me to the ER. And guess what the ER doctors have to do? They are required by law to resuscitate and stabilize me. Doesn't matter how many times it takes or what's happening to me. But if I have a do not resuscitate document and I carry that with me, they don't have to do any of that. If they come in here and I'm not breathing and my heart has stopped and I have that do not resuscitate, quietly pick me up, bundle me in, and we move on. Very, very important, especially if you're on hospice care and you're at home, to have that with you. Lots of families can say that they're comfortable with you dying at home and can say that they're very comfortable with hospice care. Hospice doesn't sit with you 24/7. A lot of families at 3 a.m. when grandma starts to turn blue or gurgle or have difficulty breathing will panic and call 911. If they call 911 and you do not have a do not resuscitate, then despite your wish to be home and on hospice care, you will be resuscitated and transported to a hospital where everything will be done. Yes, ma'am. Exactly. So that do not resuscitate has to transport with you. So if you do go to the hospital, you take it with you, and then you have to make sure that it's in your discharge packet of paper to go back with you. The other thing to be vigilant about is if your loved one gets placed into any type of a facility. So insurance stops paying the hospital. They just need comfort care. You don't want to take them home. You choose a skilled nursing facility. Skilled nursing facilities have their own medical staff. They have their own internal doctors. That doctor is the one that you want to sign the DNR at the nursing home, because that doctor is the one that controls what happens to you there medically. So a lot of times you want to have that replaced or updated as well. But you as a family member or as a healthcare agent have to be vigilant in transporting that DNR for your loved one. Yes, ma'am. So we do joke about that a lot in my office, about tattoos and what you could permanently attach to your chest and what you cannot. If you can encourage your doctor to visit the tattoo parlor with you, and get the tattoo artist to maybe make a little yellow block with a red stop sign and look like the Department of Health and Human Services form, and your doctor will take the wand and sign for you, you could, I suppose, have a tattoo that would work for that purposes. Unfortunately, it's a shame that it's hard to die. Okay. Yeah, you want to make sure you're able to revoke it. So sometimes people recover a lot better than they thought they would, and they decide they're going to hang around a little longer. The other form I want to tell you about is a bright pink form called the MOST form, Medical Order for Scope of Treatment, but everybody should know it by MOST, M-O-S-T. That bright pink sheet of paper. It's a two-sided form, and it comes from the Department of Health and Human Services. You can't get it. Only doctors can order it. Again, it's a doctor's order. I like it much, much better than the do not resuscitate, because the only thing the do not resuscitate helps me with is my cardiac arrest. But what if I pass out and I just don't feel good and they want to start IVs and they want to, take me to the hospital and run me through tons of tests, and maybe I already knew I had a terminal illness and I really didn't want to go back to the hospital and I really didn't want another MRI done. I just wanted to be at home and be comfortable. The MOST form lets you and your doctor answer all of those questions in detail. So your doctor can sign and say, she only wants limited care. Don't take her to the hospital and put her in all the machines and poke her and keep her there for 3 days. We already know what's wrong. We already know what she's going to die from. She wants comfort care and she wants limited treatment. I had grandmother, very, very dear to me, but in the end of her life, she had congestive heart failure and kidney issues. Well, my goodness, that's really, really hard to balance out, because congestive heart failure, you're retaining too much fluid in your body. We want to get rid of that fluid so your heart and your lungs can work better and you feel better. But how do we get rid of fluid? We get rid of fluid through our kidneys. So then we overwork our kidneys, right? Well, what does every EMS guy that shows up at your house do? Run an IV line, right? Part of their standard orders. It's not their fault, but they got to run that IV line open. We can go way, way back to the 70s and watch that emergency show I used to love after school, and always had to get that lactator's ringer started. Nurse Ratched, probably. But so we wanted things in place so that she wasn't just pumped full of fluid. It did her kidneys in. It created more congestive heart failure. So you and your doctor get to go through all those little scenarios and decide what you want and what you don't want. Again, it's a signed original. You have to carry it with you. You have to keep it on your fridge at home, have it at all times. So if EMS gets called, they know what to do. Medical releases. This is my very last comment. And okay, go ahead. Go ahead.
It's way back, but I just wanted to know. It's an understanding you're executive administrator, whatever. Must live in the state.
Yeah, that's a terrible misunderstanding. So yeah, I hear it all the time. So here's how that actually works. By law, the clerk of court gets to approve who gets to be your executor or not. But what does the clerk of court do? They look to your documents, right? Well, I hate to tell you that if your son's a felon and you named him as your executor, the clerk's probably not going to let him oversee your estate and have control of all of your assets. He might be a convicted, money launderer or something. So she has the authority and the discretion to not approve him. If he's under 18 and you die before he reached 18, he's not able to be an executor. So there's a small list of things that you're prohibited from being an executor. Living in North Carolina is not one of those. However, the local clerk of court currently, who's retiring, and we just had our Republican primary and found out who our new clerk of court will be. I do not know the new clerk's position on this. The current clerk of court says that if your executor is out of state, they have to have an attorney listed of record to assist them. The reason for that is that she was getting, for years and years and years, way too many kids that flew in for the funeral, qualified on the estate, grabbed the assets, and headed out west. Never came back and filed any paperwork, never finished up the estate, left all these messy trails for all of us doing title work and other things here. And she can't reach beyond North Carolina. So she's a clerk of court in Moore County and she has jurisdiction in North Carolina. So one of us local practicing probate attorneys gets stuck on that record hired by the son, and then she can get us. And so that's kind of her way to make sure that that son does what he's supposed to do. Do they all? No, we just get notice after notice and try to reach our client and get them to do what they need to do. But for the majority of them, they take it seriously. So some people worry about the added expense of that. That just depends on what attorney you hire and what their arrangement is. Some attorneys have set fees, some attorneys do hourly. Some want to be involved in all of it. Some will take a very limited role, and that's all up to your son at that time. But they are not prohibited from qualification. If you have someone from North Carolina, they can handle the estate without an attorney being listed of record. Okay. You're welcome. Medical releases were the final document I wanted to throw out there to you today. I know that HIPAA has been around for a while now. That is the law at the federal level that says don't share health information. You know, overall, that's great. I don't really want all my blood test results floating around being posted on Facebook either, but do I want my family to be able to call into the nurse's station and check on me and get a nurse to talk to them? Yeah, that's probably a pretty good idea. Unfortunately, the law basically prohibits all of those things. So you have to draft around it. You got to have people named that you wish to have access to your protected health information. A lot of my clients say, hey, I don't need another document. I don't want the HIPAA release form. When I explain to them that the form that they have with their primary care physician expires if it's not kept up to date regularly in the doctor's file, most of them agree, oh yeah, I better sign that. And what if you're at the beach on vacation when you get sick? Your primary care doctor isn't going to, most of them are not going to head down to the beach and try to check on you. They might if you're at the beach. That's probably a good idea. But so it's a simple form. Most every attorney does them. HIPAA release, medical release of information, authorization to release protected health information, whatever they call it. It's just kind of a general document that lasts for a really long time. You don't have to replace it. And then your family can contact and talk to people, especially if you have like a really good friend or you have a significant other that's not your spouse or not named in your documents. Really good idea to make sure that that person can kind of bust through the ER and get back there with you and start advocating for you and filling you in on things or updating your family. All right, so next week we're going to do kind of a case study. Talk about, oh, wow, I'm getting old, I'm aging. Now what do I do? What are the different levels of care? Do I want to do that at home? Do I want to go to other locations? What are my living options? And what kind of benefits or programs might help me pay for that? I'm more than happy to stay here and answer questions, especially since we started late. So I'm just going to start calling on people. I'm starting on this side of the room, moving this way. But if you come up with a question, I'm happy to come back. Lynn, I don't know, can people online ask questions in a chat box or not? Okay. So you wonderful people out there watching in wherever you are, probably maybe at the beach or somewhere really nice. If you have a question, you can go to the chat box and enter your question, and Lynn will let me know about that as well. Yes, ma'am. So her question was regarding whether you can transfer your property upon death with a transfer on death deed. You cannot. North Carolina does not have a way to transfer real estate upon your death. So you have that with your brokerage accounts, you have that with your CDs, your bank accounts. You can choose who you want to receive it after your death so that you don't have to add them to the account during your lifetime. I discourage my clients from adding children to their accounts during their lifetime, because anything bad that happens in that child's life then attaches to your account because it's their account too. So naming them as a beneficiary, transfer on death, payable on death is great, but there is no law in North Carolina that allows you to do that with real estate currently. There is a bill, but it didn't make it out of committee, and I'm not sure where it's going to go. So maybe next year we'll have that opportunity. Yes, sir. Oh, sorry. There's really not. Attorneys are not, they're prohibited by law from setting fees or discussing fees amongst themselves. And so I have no idea what a standard fee would be. I think most attorneys would probably do it based on hourly. Yeah, as far as I know. Yes, ma'am. So you are more than welcome to title a car in North Carolina joint with right of survivorship. If you only place 2 names upon the title, each of you own 1/2 of that vehicle. If you make it designated joint with right of survivorship, which there is a specific DMV form that you can do that, or you can do it with the dealer at the time, but the dealer doesn't really care about your estate planning. You can certainly add a child or have a parent added onto a child's title. I just encourage you to think about liability issues, okay? Because once you're both on the title, there is case law in North Carolina, and personal injury attorneys could tell you much better than I could exactly how that works, but you have to prove. So let's say my husband and I are at home aging, rocking in our chairs on the porch, and I know he has dementia, and I'm concerned about him driving, and he got lost last week, and he says, okay, I'm going down to the store right now, I'm going to head out, and he takes his car titled in his name and insured in his name. What is my liability? I can tell you right now that if that car was owned jointly by us, I'd be in the courtroom with him if he causes an accident and I get in trouble. If it is titled separately and I had no way of physically stopping him from leaving, I at least have an argument that I was not liable for that car accident because my name is not on it and the litigator has a harder time getting to me. Doesn't mean they wouldn't, but so, kids on cars, kids can be expensive, kids can drive late at night, kids can be tired coming home from work, so car being titled together with them might not be a great idea. Yeah. Yeah, that's kind of a loaded question without knowing all of the details because you don't know whether you're going to be probating the will anyway. Transferring a car after death is honestly very simple unless it's the only reason that you need to open an estate. And if the car is the only reason, then you may want to transfer it or jointly register it. If I was driving my legal assistant's car because my car was getting an oil change and I didn't have a car, my car insurance would still cover me as a driver driving her car. So you don't have to worry about the insurance part of it. You're still covered when you're driving someone else's car. It's the ownership issue. Yes, ma'am. Right. So excellent advice from a local CPA who's absolutely wonderful at everything she does. So just when you are adding people onto things and titling things in their name, other than just a beneficiary designation, you are making a gift. And we talked about gift taxes and we talked about limits, and you need to file those gift tax returns, and they are due before you file your personal income tax return the following year. So if you file your personal income tax return in February because you got all of your stuff in, you need to make sure your gift tax return gets in at that time as well. Yeah, so don't take gifting lightly is really the rule. You want to, before you gift an asset, you want to meet with an attorney. I encourage people, I always tell my clients that I really like for them to be the center of a triangle. And if you looked at notes in my client files, you'll see lots of triangles with a little C in the middle. That's you, the client. So I'm the attorney. I'm one of those spokes on that triangle. But then you need your CPA, your tax advisor, and you need your financial advisor. Highly recommend that not be the same person. You're getting no double check in the system. You're getting no outside advice. You're getting no second opinions. I really love my clients to have an attorney, go to the CPA for the tax advice, and get your financial advisor involved as well. And you always stay the central focus of all three of those people right in the middle of that triangle. Don't do it and ask for help later. We have a much harder time getting you out of trouble than saving you from trouble. Yes, sir. It's changing. All right, so let me quickly, for the people in TV land or watching this on YouTube later, gentleman had excellent idea. One was to check Charity Navigator online, to check the charities that you're thinking of leaving money to. It'll let you know how much really goes to the people or the things that you want to help versus how much is going to the CEO. There are some very, very bad charities with self-interested people calling themselves charities. So excellent advice. You can also get a designation that you are a U.S. veteran on your North Carolina driver's license. So if you are a veteran, you take your veterans card and information to the Driver's License Bureau, and you can get that reissued with that on there. Really awesome for discounts that veterans are given, but also could help in the event of an accident. If you're linked into the veterans healthcare system, they may be able to pull a lot of information and contact family. So wonderful things. And who else has a question? I won't comment on anything else. Yes. No, you're not. So there are all kinds of ways to avoid the actual administration of the estate. You are going to probate your will. So the word probate gets misused a lot by all kinds of people. Probating a will is the acceptance of the will as a legal document by the clerk of court. Administering the estate is the full open administration of the estate, where you would run the creditor's notice and pay things and everything else. So you can do things short of a full administration. There's affidavits of collection, there's special proceedings for spouses and minor children, and if you have small estates, things can be assigned. Well, you can legally see. Okay, so I actually have a little difference of opinion. If you're going to have a family that's going to fight, and a lot of people come to see me because they already know it's going to happen, I actually like the probate of the estate because there are things that I can do at the beginning of an estate administration to knock those people out. Give them their one chance to come and be heard and complain about what mama did, and get kicked to the curb, and they're out of my way the rest of the time. I got a call one time with two nieces feuding over a shower curtain. They were trying to divide personal property. I charged $2.75 an hour, and they wanted to fight over the Walmart shower curtain. It happens. But what I told them, okay, I'll come and get the shower curtain. I'll schedule a hearing at the clerk of court's office. She'll hear us in about 2 weeks. We'll walk into her office and the two of you can fight over a shower curtain. If I have a trust and that shower curtain was being distributed in the trust, guess where I have to go? I've got to go to Superior Court and deal with a Superior Court judge. I don't do litigation, so I don't do that. That means we need another attorney to come in and do litigation over a trust. You can fight a trust. You can fight a will. You don't avoid the fight because of a trust. Okay? Yes, ma'am. Okay. So it's $120 currently to open an estate in North Carolina and be appointed as the executor of the estate. It's about $200 to run the creditor's notice in the paper. That just depends on the newspaper and where you are. Some places would be more, some are less. And then for the assets that are flowing through your will, those are called probate assets. The things that don't have a beneficiary, don't have a joint owner, not real estate, those assets are charged a fee of $4 per $1,000 worth of property. So that might be a car or half of a car. And we use the Kelly Blue Book values usually, or the tax value of the car. Your household furnishings and your miscellaneous personal property. But I insult every one of my deceased clients with that number because we have to put down what you'd actually get from a yard sale or an estate sale, not what you insured your valuables for. An individual account. So I die with an individual checking account because my spouse predeceased me and I didn't name my kids as the beneficiaries. Those are kind of the standard ones that I see. Stocks, bonds, retirement accounts, 401ks, 401bs, life insurance, annuities. Most of those I tend to see beneficiary designations on, and those beneficiary designations override your will and they override your trust. So you need to, as part of good estate planning, you go and you look at and you check all of those beneficiary forms and make sure that they are doing what you want them to do. They're not controlled by your will, so they're not part of your probate estate. So there's no fees. Cost of the trust to be prepared and to be funded. And that would be different based on every attorney. So if that attorney is going to charge you $2,000 for a trust, are you paying that out of your pocket now because your probate costs are going to be in excess of $2,000? Okay, just as an example. So that's how I run it for clients when they come in and tell me where their assets are going. And we draw these little boxes and funnel them in. And I don't want them to pay me to draft a trust if there wasn't anything coming through the probate estate and we weren't even going to probate, because that's nice for my kids and their college fund, but it's really not helping my client avoid anything. Okay. You're welcome. Minor child should hopefully never be a beneficiary of anything. And so that's where, if you're using a trust, you're going to catch it in a trust for the minor child. If you're using a will, you're still going to do a minor child trust or have a general provision in there to catch it and have it managed by someone else. Anybody under the age of 18 in North Carolina cannot enter into a contract or make their own decisions when it comes to money. Exactly. Yeah. Yes, those are very upset wives when you meet them later. So for a will, if you get divorced, so I'm a husband in my will, if I were to get divorced, he is no longer included in my will because he was referenced as my spouse. But if he's on my retirement account as the beneficiary, or my life insurance policy as the beneficiary, he still gets all of it. So the divorce did not take him off of all of those documents, which is exactly what you experienced in your line of work. Yes, ma'am. Sorry. Yes. Mm-hmm. That's fine. You want to name the best person. Mm-hmm. That's okay. You want the right person to make healthcare decisions for you. So when you choose who the person is, just choose the right person. It really doesn't matter where they are. Understand that if they are all out of state, don't answer their cell phones or read emails like my son, you may be hooked up or hanging out a little bit longer at the hospital than you wanted to, but that's okay. If that's the person you want to make decisions, there's no problem with that. Mm-hmm. Yes, ma'am. A healthcare agent can make decisions by phone. If they needed a release signed, they might send it electronically. They might fax it. They may have you scan it back to them. It's perfectly fine to not live here. Now, it does get hard when they're out of the country just because of time change and limitations on being able to call overseas. There aren't too many ER doctors that have, access to toll-free lines to call, Africa if your son is currently teaching English there as a second language or something. So we see that a lot with military children. Military children are awesome, and I appreciate their dedication to our military and our country, but they are very hard to keep up with and find when there's a crisis. So keep that in mind. Okay. No, you are allowed to die wherever you want to die, but yeah, it's not, no. So what you want to be really careful about, though, is how your death certificate's prepared. Because if they accidentally prepare you as an Illinois resident, because maybe you had a bad stroke and your son took you home with him for a couple of months and you were going to stay there, or he had a really nice nursing home down the street from him that he wanted you to be in, and we knew you only had a couple months. If you did not choose to go to Illinois and become an Illinois resident, then your residence is still here. But if that death certificate gets completed that you lived in Illinois, I'm going to have a fight on my hands with the Moore County Clerk of Court in trying to present her with a death certificate in your will and argue that you were still a resident here. I can get around it, but it's one more step we have to take. So when they fill out the thing, they say, well, you died here in Illinois. However, you were a resident of North Carolina, and they give your address here. Okay. Yes, ma'am. It's a gift. Definitely. And all real estate needs to be fully appraised by a certified appraiser at the time of the gift. Because if I file a gift tax return and I do not include a certified appraisal with it, the statute of limitations on recording that deed and filing that gift tax return never runs. So an example there would be, I decide to gift my house to my children now, and I convey that deed, and I have an appraiser appraise my house, and I file my gift tax return, and I get that to the IRS. The IRS only has 3 years to challenge that gift tax return. So when year 4 rolls around, I know that they can't come back and argue about the value and use a bigger piece of my exemption on my ledger up there. If I file it without a certified appraisal, I just attach a tax listing or something that my realtor friend said that I was allowed to attach. Then the statute of limitations never runs. So I die 10 years later and my kids file my estate. And what do you know? I have a taxable estate. Well, guess who's going to go back and look at that gift tax return that the statute of limitations never ran on and grab that gift and put it back in my estate and charge me all over again? You'd be in violation of federal gift tax laws. File a gift tax return and tell them you made a mistake 10 years ago and beg for forgiveness, and hire an appraiser to do an appraisal from 10 years ago, which will take a lot longer and be a lot more expensive. Anything you add is a gift. So if you're a single person and you own a house and you add a child, it's presumed to be 50-50. If you add a child and give them a 1% interest, you can argue that it's 1%, but you still need the appraisal of the whole. Yeah, you also, a really important thing for giving property to kids, kids can kick you out. Kids don't have to let you stay. Kids can sell your house out from under you, and I've seen it happen, and it is the saddest thing you can ever be involved in. Kids can also cause a car accident. Kids can get divorced. Kids can lose their jobs. If you think back to 2008 and 2009 and what your friends or parents were dealing with, a lot of those kids and grandkids moved home. We had a lot more young people in Pinehurst and Southern Pines than we did before because they just had nowhere to go. Well, they were filing bankruptcy. They lost their jobs. There was nothing they could do. It was the economy. They didn't do that on purpose. But guess what? If they owned mom and dad's house, guess where the bankruptcy trustee came? And then the family had nowhere to live because mom and dad had given it to the kids. Why give it to the kids? Why not keep it and let them inherit it? If they inherit it, they get a step up in basis. So what that means is I give my kids my house today, and maybe it's worth $300,000, and maybe I only bought it for $200,000. My tax basis is $200,000. That's what I gifted to my kids. If they sell it next week for $600,000, they have a $400,000 capital gain they have to pay a tax on. If I died and left it to them and it was valued at $600,000 when I died and they sold it for $600,000, no capital gain. So you got to go through the whole process of the good, the bad, and the ugly with gifting to figure it out. You cannot reverse a gift. You can't just have the kids give it back to you and say, ooh, we made a mistake. I'm getting my property back. That you can do that legally, but the kids are making a gift back to you of the value of that property. So then you have your kids and wherever they live, and that's state law. A lot of states tax gifts. We don't here in North Carolina, but if your kid's in Virginia and they own your house and they deed it back to you because you didn't file a gift tax return or take care of it, then they have to file gift tax returns and pay gift tax because they gave it back to you. And they can't give it back to you when you're under hospice care and you're going to die right away, or it gets recaptured in the estate anyway because the IRS knows what you were really trying to accomplish was a step up in basis and cut your income tax. Okay? Scared enough? Enjoy your day. You're welcome. I hope I see most of you next week.
Thank you for everybody attending, and thank you so much, Jennifer. And we will see you next week. Thank you so much. Bye-bye now.